goes on. Letting the law clerks in. I'm going to ask Mr. Topic to unmute. I am beginning the recording and letting IT know we can begin to broadcast. Oh yay, oh yay, oh yay. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-5074, Patrick Eddington, appellant, versus United States Department of Defense. Mr. Topic for the appellant, Ms. Walker for the appellate.
Mr. Topic, good morning.
Good morning, Your Honor. Thank you, and may it please the court. Appellant agrees with the Defense Department that merely sending a request is insufficient to trigger an agency's response if it was never received. At the same time, emails do not typically disappear into the ether, and therefore evidence that an email was sent is highly probative of whether the email was received, especially when inferences at summary judgment must be resolved in favor of the non-movement. I'd like to focus on why the district court erred in relying on the presumption of good faith to resolve a genuine dispute of fact in favor of the department under the specific facts of this case. The department has never disputed that if the requests were delivered to its email servers, they were received under FOIA regardless of what happened to them after that. And it recognized that FOIA requests could be routed to spam folders because it checked them in response to this suit. What it has never addressed, however, is whether its email system was configured to automatically delete unread spam after a period of time that passed by the time the department looked for the emails after the suit was filed. Therefore, the fact that the emails were not located months after they were sent was insufficient to grant summary judgment for several reasons. First, under Rule 56, inferences must be drawn in favor of the non-movement. Instead, the district court inferred that the emails were never received by the department's servers from the fact that they were not found months later in anyone's email account. That is precisely the opposite of what Rule 56 requires. Second, the presumption of good faith was inapplicable. Under Safeguard, which the government cites in its brief, the presumption only applies if the agency has adequately investigated and described the relevant circumstances for its claims. The department has not conducted any investigation into automatic deletion or described the relevant circumstances of how it works.
Why don't you just resend them rather than bring a lawsuit?
Yes, Your Honor. So first,
there's no statute of limitations problem here on FOIA.
Correct. I mean, from our client's perspective, he sent the request the way he was supposed to. There has not been an adequate explanation as to what happened to the request. The government hasn't addressed a very likely scenario of what happened. He filed suit, he paid his filing fee, he put the effort into filing a lawsuit, and to start over again at the back of the line, would be a rather tough pill for a requester to swallow in these circumstances. I won't get into any settlement discussions we had with the government. I can tell you we certainly would be amenable to try to work something out that doesn't put him back to the back of the line. But I think the same question could be asked of the government. You are aware of these requests now for several years after the suit was filed. Why not just process the request then? I mean,
if he had just filed 21 days after he originally filed, he'd only be 21 days behind the line.
If he had started over, at that point, yes, he would. That'd be the amount of time that passed in between. I mean,
he could have presumably called, I think, and said, I filed this 20 days ago. I haven't heard back. I'm refiling today. Can you see if there's some technical glitch on your end? It just seems kind of like what a normal person would do.
I don't know whether these components make a phone number available to contact anyone. I know many components don't, but unfortunately, the reality is that it's not at all uncommon for FOIA requests to be ignored, for follow-ups to be ignored. If we were in a situation in which agencies routinely responded to requests in a timely manner, then it might be a different situation. Then a requester might think, geez, something must be wrong here, because they normally respond to requests. But that is just simply not the reality of how most government agencies operate their FOIA programs. They frequently violate the deadlines. And so it's not at all unusual.
Is there evidence? You're making factual assertions. Where's your evidence?
In terms of government FOIA practices, there's right. Yeah, that's not an issue that was litigated below. That's not something that's in the record. I took this to be sort of, kind of pragmatic questions about, isn't there another way that this could have been addressed? And I'm endeavoring to respond to those questions. But ultimately, if they were received, none of that matters under the statute. If they're received and they weren't responded to by the deadline, a requester has a claim that can be brought at that time. There's no obligation to go through any further process if a request hasn't been.
I understand that, but you said if they were received, and that's the problem. Is it's really, really hard to know if they were received. There's nothing to suggest that they weren't received. And I mean, just off the top of my head, I can just think of a half dozen, maybe a dozen things that after the original 20 days went by without a response, that your client could have done. Everything from, I think he sent them from a somewhat unusual email app. You could have tried sending them from a normal email app. He could have everything from as simple as that to something as, taking the subway over to Pentagon and going into the lobby and asking to talk to somebody who, deals with FOIA. It's a public building. I'm not saying they just let everybody in without, a reason and a security, but, maybe somebody would have come down to meet him. All that seems so much easier than filing a federal lawsuit.
Yeah, I certainly appreciate that. I don't know what luck Mr. Eddington would have if he just showed up at a government office and asked to talk to a FOIA officer.
What about my idea of just sending it by Gmail?
I don't know that we would be in any different position here. I mean, to frame where we are, it's a summary judgment motion filed by the government. Are there explanations for what happened that would mean it wasn't received? Sure. There's also explanations that the government very easily could have addressed in its declaration. I mean, that really is the only thing we've identified is a possible explanation that's consistent with all the evidence that was before the district court was that
I will ask the government how different the 14 different units are in terms of servers and emails and systems and processes. But if there's some difference between each of the 14 units, your theory is that 14 independent actors all messed up. And their theory is that you messed up. And I'm anything but a expert on philosophy, and Occam's razor comes to mind. But the simplest explanation there is not that 14 independent people had a computer problem, but that you did.
So I think I can clarify that, Your Honor. So we're not saying that 14 independent people got the requests into their inbox and chose not to respond to them. What we're saying is that the most likely explanation is that it's something with the way the government configured its email servers. They're all part of the same department. So it isn't 14 independent actors. It's one government email system. And so certainly if they have answers to questions about how that's configured, that will be helpful. But that's the kind of evidence that should have been presented at summary judgment. And at the end of the day, it's a summary judgment case. The inferences are supposed to be drawn in our favor. And the district court took the opposite approach and put all the inferences in favor of the government. I'm in my rebuttal time, so I will happy to answer any additional questions or handle them in rebuttal.
All right, Ms. Walker. 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 Ms. Wal
Thank you, Your Honor. May it please the court, my name is Anna Walker and I represent the Department of Defense. Today, we ask the court to affirm summary judgment because the appellant has not demonstrated that the Department of Defense received the FOIA requests that he claims he submitted to the Department of Defense. To answer the question that was raised just previously, I did check with the Department of Defense. Each of the 14 components that the requests were sent to have different email servers, but we would submit that this argument actually is not right at this point for the court to consider. Had the appellant raised this argument during the summary judgment briefings in the detail that he is raising it now, we could have addressed this matter really simply with a supplemental declaration that disposes of the issue.
Ms. Walker, did I just hear you right that the 14 units did have 14 different email servers?
That is correct, Your Honor.
So, I mean, that seems, I'm not saying we need this information to side with you, but to me that's just, it makes the appellant's theory, go from unlikely to, exceptionally unlikely.
And Your Honor, we would say that our evidence in the initial declaration was actually very strong that the appellant's argument was very highly unlikely because of the fact that each of the components checked its email folders, including its spam folders and its FOIA logs, where FOIA requests are automatically intaked and recorded and did not find any evidence of the request. In addition, the declaration explains that had the request come in, each of the components would have sent an acknowledgement in some form or another to the appellant, and appellant has made no demonstration that he received any of these acknowledgement letters. And we would submit that this evidence alone is sufficient to show that it really, there's no evidence here of actual receipt. We would also point out to the fact that appellant's argument that asking the court to speculate about the possibility that his FOIA requests were automatically deleted from spam folders before they were checked is a bit of a red herring because it conflates the issue of what is sufficient to establish that an agency conducted a reasonably calculated search for responses to a FOIA request with appellant's threshold obligation to show that he submitted a FOIA request in the first place. In other words, the crux of this case is whether the appellant has actually submitted a FOIA request, and here the evidence is overwhelming to show that he did not. It is the requester's jurisprudential obligation to establish that he has exhausted his administrative remedies by submitting a FOIA request in the first instance. His evidence in this case simply does not meet this obligation. And so we would say that on this grounds alone, the court can decide to affirm the trial court's decision. Specifically, he points to only two pieces of evidence to support his claim that the department received his FOIA requests. However, neither of these pieces of evidence is probative of actual receipt. First, he points to the fact that he made PDF copies of emails that he allegedly sent to the Department of Defense's 14 different components. However, these email messages do not indicate that they were actually received by each of the 14 different components. In addition, he points to the fact that he received no bounce back or error messages after he submitted the emails to the Department of Defense. But we would submit that this evidence is just as probative of receipt as it is to the fact that he never submitted the emails the correct way in the first place. And so while we would say that it would be very difficult in this case for him to show receipt, especially against the department's declaration that establishes that an agency that processes over 50,000 FOIA requests each year has no record of receiving his 14 FOIA requests, there are additional pieces of evidence that appellant could have cited to perhaps bolster his argument of receipt. One of those pieces of evidence could have been an email header that demonstrated that the emails that he sent to the Department of Defense were actually received by the Department of Defense's 14 different email servers. In fact, the Court of Federal Claims uses evidence exactly like this to demonstrate when a bid submitted by a contractor has actually successfully submitted his bid to the federal agency that he is sending the bid to. In addition, appellant could have cited to read receipts, which indicate that the email potentially was actually received by the intended recipient. And we know that other courts across the country, including the Sixth Circuit, has used this as circumstantial evidence to establish receipt. He has not pointed to either of these additional pieces of evidence, and he has also not pointed to the fact that his actual pieces of evidence are sufficient to establish receipt. And so for that reason, he has not upheld his burden to show that the department actually received the FOIA requests. I'm sorry, Your Honor, I can't hear you.
All right.
I'm sorry. It's not your burden to have a theory for what happened here, but do you have a theory for how? I mean, I believe Mr. Eddington thought he sent these. He pressed a button on an email app, and after he pressed that button, it was his belief that the email was sent and likely received. Do you have a theory for why they weren't received?
Me personally, I don't have a very strong theory, except for the fact that they were never actually received. I do believe he intended to send them, but I echo the court statement earlier about the AirMail app not being one that perhaps is typically used when submitting requests, or at least not an email client that a lot of people use. And so email clients can sometimes malfunction, and so that would be one possibility.
The
department?
No, please go ahead.
Okay, thanks. The Defense Department has now received these requests, haven't they? Through you.
Yes, Your Honor, they were attached to the complaint.
So why don't we just wait 21 days and you respond? Or not you, but the various compartments or departments. What's all the fuss about?
Your Honor, the biggest problem with responding to the FOIA request at this time is that it would be unfair to the requesters that have submitted their requests that were actually received by the Department of Defense, because the Department of Defense processes their FOIA requests on a first in, first out basis, which was affirmed
wait a minute. These requests are now have been, quote, actually received.
If that's I misspoke then, if that is what I intended to say. They have not been received through the proper channels. They have been attached to the complaint. We have them, we're aware of them, but they have not been submitted through the proper channels of actual submitting a request to the Department of Defense. And it upholds the order of administrative processing to do so in this case. And we would also submit that not only does it create an unfair advantage to start processing this request that hasn't been received the way other requesters have submitted requests to the department, but it also creates a dangerous precedent where the department could now suddenly be liable for FOIA requests that it never received in the first place. And it also creates a situation that might lead to chaos down the road, where the department is now looking at requests that it received or is alleged to have received by a requester and trying to determine exactly when it received it. And these are reasons why the court in Houston and FERC versus Michigan have declined to use any presumption of receipt from a date earlier than actually receiving the request through the proper channels. And so we again submit that the evidence here is simply not sufficient to show that appellant has met his burden to establish a genuine disputed material fact that the agency received the FOIA request. And so for this reason, the court can affirm summary judgment by the district court. We also submit that, again, separately, the court could also affirm judgment by the lower court simply by the fact that appellant has not established his jurisprudential obligation to show that he exhausted his administrative remedies by submitting a request in the first place. I see that I'm running short of time, so if there are no further questions for all of these reasons, we ask that judgment be affirmed.
All right, thank you. Mr. Topic, I think you have a minute or so left.
Thank you, Your Honor. As to Houston and the cases rejecting the prison mailbox rule in certain circumstances, the government is conflating the presumption of receipt with what date you use, whether you use the date of mailing or the date of receipt in statutes that use language like submitted or filed. Those are not cases that rejected a presumption of delivery. That was simply a question of which date do you use. It's not an issue, and there are plenty of cases applying the mailbox rule to a presumption of receipt and also doing that when it comes to email. The last thing
do you know why your client took, I think it was 7 months to file suit? And I asked in part because today you've emphasized that he's in a hurry.
I don't have an answer to how that timing worked out. What I would close on, if I may, is this would be a different case if this had not been at summary judgment and the district court's decision. If you go back to the way inferences are supposed to be resolved at summary judgment, we've come forward with more than speculation to rebut the government's evidence, and more should have been required before summary judgment was granted.
What's the remedy you're seeking?
Well, I think it should be remanded with instructions to vacate summary judgment, and then the district court has a number of options available on how to resolve the case. It could give the government an opportunity to submit a second set of affidavits that address the issues that we have raised. And if they were to do that, the case would be in a different posture.
Are you asking the district court to order the government to respond within 21 days or 2 weeks or what?
Well, we have not filed our own summary judgment motion asking for any relief. The government has asked that the case be dismissed based on it not being received. And so,
so what do you get if you win?
I think what we would get if we win is that either the government would have to furnish more detailed affidavits to meet its burden, or the district court could allow limited discovery into those questions instead of affidavits. And then ultimately, we would want a finding that it was received through another set of briefing in a motion that we have not filed at this time.
All right, if there are no more questions. Thank you, counsel. And Madam Clerk, if you call the next case.
Case number 20-1315 et al. Louisiana Public Service Communication Petitioner versus Federal Energy Regulatory Commission. Mr. Fonten for the petitioner, Ms. Berry for the respondent.
Counsel, good morning. Please proceed.
May it please the court, Mike Fonten for the Louisiana Commission. This case boils down to FERC's different treatment of this case from its prior decision in the fourth bandwidth proceeding, which held that even if prior cases have been litigated to a full conclusion, and even if every party in those prior cases had the opportunity to litigate the issue, seek rehearing on the issue, and if they had sought rehearing, taken a request for judicial review, that you're still required to reopen the prior cases and correct the inputs. That decision was issued in opinion 545 preceding this decision, and it caused a great significant reduction to Louisiana consumers in the receipts for the bandwidth. In this case, and I might say this, that prior case involved the sale leaseback, the Waterford 3 sale leaseback, the same asset. In that case, FERC reopened the issue of amortization of that sale leaseback, which is basically depreciation, and corrected the prior inputs in order to change a faster depreciation rate to a slower depreciation rate, taking costs out of the bandwidth. Now, in this case, FERC's final ruling was that the sale leaseback accumulated deferred income taxes needed to be in the bandwidth because the formula required it. This case started in 2010, just like the fourth bandwidth proceeding started in 2010, but it was decided later because of an abeyance. FERC's rule with regard to going back was a surprise to us, and it certainly, I think, was a surprise to everybody else. We had requested in our case that the relief should at least start when we filed the case, and it
What is
shouldn't
the
be,
relief? What is the relief?
the relief. Yes, Your Honor. Well, the tariff violation was true of all the years starting in 2005. FERC gave us relief only from 2010 forward.
But
So it denied
what is
relief.
the, excuse me, what is the consequence of the relief? Is it to increase the cost of production?
Well, Your Honor, this is a bandwidth. I don't think you have sat on a bandwidth case, but basically the higher your costs are in the bandwidth, the more you will receive from a low-cost company. If you're a high-cost company, then a low-cost company may have to pay you to bring you within the bandwidth.
And when those payments come in from the other companies, if you won, and they would come into the Louisiana arm of energy, right? Now,
Yes, Your Honor.
what does the Louisiana arm of energy do with those payments?
Gives it to consumers. All of these bandwidth costs or receipts are flowed through to consumers because under Supreme Court rulings, preemption requires a state commission to pass through to consumers any cost that's assessed by FERC or any refund that is given back by FERC. So, all the consumers have to pay the costs of energy. And if they're entitled to a remedy that eliminates discrimination, some receipt under that remedy goes to them.
And how much money are we talking about in terms of projected payments from the other companies?
Well, Your Honor, the amount changed every year. I believe, and this is ballpark, please understand, I believe it would be on the order of probably $20 million for 2005, and then reducing down to about
the $20 million is the component that would be added to getting the cost of production. That's not my question. My question is, what effect would that have, if any, on the amount of contribution from the other entities?
Your Honor, that's what I was addressing. I was trying to address, after it flows through all the permutations of the bandwidth, the amount that would come out. And the amount of ADIT is maybe over $100 million. So then the amount of the ADIT provides, should have received a rate of return of $10 million or so. If it was 20 million in 2005, it was gradually reduced because the sale leaseback was being amortized.
Where can I find in the record support for what you've just said, that quantified, a quantification of the effect on Louisiana consumers of electricity? Where in the record can I find it?
Well, Your Honor, it's in the record because they did provide a refund in a compliance refund report for the 2010 forward. And then it would be for the prior years. They obviously have not made compliance refund reports. And, you have to input the amount into a model that then goes through all kinds of permutations, and you find what the result is.
But where,
we're talking
my
about,
question, sir, is where in the record? Can you cite a page? Can you cite a something in the record that quantifies this number?
I do not believe there is anything in the record that quantifies this number for the prior proceedings.
Then how do we know that?
Because-
Then how do we know that you have standing?
Oh, you know that I have standing, Your Honor, because if it's 1 penny of additional cost, I mean, the lowest cost company already paid in those cases. Energy Louisiana was among the highest cost companies. It received in those cases. So we're at the margin. And if any additional cost is added to Louisiana's cost, it receives money. Now, there's no doubt in the record.
But
that
even
FERC
if,
decision-
even if, you know, I don't want to monopolize the argument, but I'm not getting an answer that makes sense to me. Even if this increased the cost of production, that does not necessarily mean that there's going to be payments to Louisiana Energy, because there's the plus 11, minus 11% difference.
They were already at, in all of those cases, the point where the costs exceeded the bandwidth already. Okay, so we're at plus or minus 11%. A payment has been made. Should an additional payment be made, because anything more adds to your cost. If your costs go up from that point, you're going to get a payment, all other things being equal. So, Your Honor, I mean, we're not saying we're starting right here at nothing. We know that they would get a payment because, you know, they're at the margin already. And if you add a cost at that point, it's going to immediately, I think the effect would be 80%. That has been worked out over many bandwidth cases, that you're going to get a higher payment because you incurred this cost.
Okay, fine. You know, why don't you go on with the rest of your argument? Yeah.
Well, the point is that they did not permit including these costs in the prior cases. I don't think my opponent will dispute that it would have an effect, Your Honor. And the reasons they gave were that FERC, that the LPSC did not seek rehearing of a hearing order, the third hearing order, which said we would get relief from 2010 forward. And when we requested rehearing to get that result, FERC had not issued this opinion 545 that says you can go back. But a hearing order is never subject. It's not final. It's an interlocutory order. The court would never review a hearing order, and it's not listed in FERC's regulations of the type of order that you have to review. The second one, they say, we should have sought rehearing over, and I see my time's out. I could probably do this.
Go ahead
in a
and
minute.
finish your thought if there are no more questions.
Yes, Your Honor. The second one they said we should have sought rehearing of on the issue of scope of remedy was an order denying relief. Well, we did seek rehearing of the order denying relief. The only thing in that order that talked about scope of remedy was procedural background, where they went through all their prior orders in the case. And as soon as they granted relief, we sought rehearing on the scope of relief. So there's, that does not in any way, shape, or form justify FERC's refusal to go backward. And the only thing left is we tried to litigate the issue in the first bandwidth case, and FERC made a legal error, an admitted legal error in that case, and kicked it out of the bandwidth, and then precluded us from relitigating in the next two cases under their policy against relitigation. So an admitted legal error on the merits is the reason why they can't go back. And that,
All right, Mr. Fonten, if there are no more questions, we'll give you a couple minutes and reply. Ms. Perry.
May it please the court, Lona Perry for the Federal Energy Regulatory Commission. The 2015 order that the commission issued in this case was a final order on the issue of whether there would be any recovery whatsoever in this proceeding with regard to the first 3 bandwidth cases. The 2015 order conclusively stated in 3 separate times that should there be a determination that the accumulated deferred income taxes should be included in the bandwidth calculation, that it would be effective prospectively from the effective date of the 4th bandwidth proceeding. And that was all. And so that conclusively determined that there would be no recovery whatsoever for the first 3 bandwidth proceedings. The opinion 545 is there as the petitioners stated in their reply brief at 15, the 545 opinion was issued on the same day as the 2015 order. Accordingly, if it was truly a revelation as to the commission's policy on the backward-looking bandwidth proceedings, the Louisiana Commission had every opportunity to file for rehearing of the 2015 order on that basis. And furthermore, opinion 545 itself said quite clearly, and the Louisiana Commission acknowledged this in their May 2020 request for rehearing, said quite clearly that it, with respect to issues that had actually been litigated in prior bandwidth proceedings, that there would be no reopening of those issues that had been actually litigated. And you can see this at paragraph 153 of opinion 545, which is in Louisiana's supplemental appendix at 451 to 452. Therefore, to the extent that Louisiana is relying on 545 as essentially good cause for having failed to seek rehearing of the 2015 order, for both of those reasons, 545 doesn't suffice as any excuse for having failed to seek rehearing of what was a very clear holding in the 2015 order that there would be no recovery in this proceeding for the first 3 bandwidth proceedings.
What was FERC's rationale for that?
FERC's rationale in the 2015 order was the fact that Louisiana requested specifically in its request for, in the 2014 hearing order, the commission set this proceeding for hearing. And the commission said in that order at paragraph 50 that the issue had been decided as to the first 2 bandwidth proceedings, but for everything after that, it had not yet been determined. On rehearing of that 2014 hearing order, Louisiana argued that it noted the finding that it had been determined for the first 2 bandwidth proceedings, but not going forward. And it specifically said rehearing should be granted only to make clear that a potential remedy and refund will not be limited to Section 206 relief, but will have application from 2010 forward. And that's in the joint appendix at 380. They repeat the same at 381, and they repeat the same at 383. It's specifically, Louisiana specifically asked for a ruling on the scope of the remedy, and the scope of the remedy that they specifically asked for was from 2010 forward. Mm-hmm. So in the 2015 order, the commission granted the request to rule on the scope of the remedy, and they ruled on the scope of the remedy by giving Louisiana exactly what it asked for, which was it would be effective from 2010 forward, which precludes any recovery for the preceding bandwidth proceedings.
So they couldn't have applied for rehearing on that issue.
Certainly they could have, Your Honor, because the
Well, they
2015,
weren't aggrieved. They got what they asked for.
they were not aggrieved because they got what they asked for, but it was a final decision on that issue. So the point being that they cannot now effectively seek rehearing on that issue in May of 2020, when it was finally decided in 2015. Either they were not aggrieved by getting what they wanted, or if they were aggrieved, having now seen 545, which was issued on the same day, if they now realized that they were actually aggrieved by this determination, they had the full 30-day statutory rehearing period in which to seek rehearing of the 2015 order. So either they were not aggrieved and this is a final order, or they were aggrieved but failed to seek rehearing, and this is still a final order. But they, under no circumstances are they in a position where in 2020, they can revisit this determination that was made in 2015.
When did this bandwidth stuff end?
I believe that the agreements between the Entergy agreement between these entities ended. Mr. Fonten will know better, but I believe it was 2018 that the agreement was finally terminated.
Okay.
If there are no further questions, thank you.
All right, Mr. Fonten, why don't you take 2 minutes?
Thank you, Your Honor. The issue, of what we could have done is an interesting issue, I think, but we had not received, when we got the 2015 rehearing order, which gave us what we asked for, because when we asked, we didn't know this policy on bandwidth proceedings that you can open finally litigated cases. Okay, so we asked, at least give us relief until starting in 2010. In a 206, you ordinarily would be cut off after 15 months of refunds until FERC decided the issue. So they gave us that. Well, then they come out with this hearing order. And as counsel just said, if we ever grant relief, we will grant it from 2010 forward. That, first of all, doesn't say anything about the past. And second of all, it's a hearing order. That it's in that category of cases that the court is very familiar with, that it could be mooted by a final ruling if FERC would deny any relief. There was nothing to review at that point. It was a hypothetical. We can't appeal.
Isn't that the way you argued it in terms of a hypothetical? By you, I mean Louisiana Commission. If you look at JA,
yes, Your Honor,
JA 380, and then you compare it with what FERC said, it looks like they actually copied your submission and put it into an order.
True. That's true, Your Honor, but it's not listed as an order you are supposed to request rehearing for in FERC's regulation. And it's not the type of an order that this court would ever review. I mean, they gave us what we wanted, that's true. But when we asked for that, we didn't know they were going to have a new rule that reopened prior proceedings. And, the rehearings there were primarily devoted to Energy asking for a dismissal of the case, which FERC denied. Energy said, well, this is raised judicata because of the prior rulings. And that's the reference that counsel refers to about whether it was litigated before or not litigated before. But the fact of the matter is it all rests, what the litigation before relates to is a legal error, admitted legal error. And, so Louisiana is cut off from relief. And Judge Randolph, I didn't hear counsel deny that there's an effect. There is an effect. So,
All right, if
that's.
if there are no more questions, we have your arguments. And Madam Clerk, if you'd close court.
This honorable court is now adjourned until Monday, February 7th at 9:30 a.m.